Hello friends, welcome back to our YouTube channel. If you like this video, please like, share and subscribe. I'll share our videos commanded by our experts, so let's begin.
If you like, please like, share and subscribe. So let's begin our today's topic. Let's begin.
Google has filed a massive 4,761-page appeal after the Delhi High Court ruled its keyword advertising system liable for trademark infringement. The court issued a permanent injunction blocking Google from using the name Hindware as an ad-triggering keyword and ordered the company to pay 30 lakh rupees, about $31,600, in damages. The ruling targeted Google's keyword planner tool, noting that it actively suggests rival brand names to competitors to maximize ad profit by diverting organic brand traffic. Justice Mini Pushkarna stated that Google was attempting to sell something it simply did not own, forcing the tech giant to mount an extensive defense to protect its core search revenue model. In its appeal, Google rejects the premise that backend keyword matching equals a public-facing trademark violation. Google argues a keyword is purely an internal back-end trigger to run an ad space auction, rather than a visible piece of branding. Because the trademarked term never appears in the actual ad copy shown to the consumer, they insist no direct infringement occurs. The core of this defense rests on strictly separating internal algorithmic logic from external legal liability. Beyond the technical mechanics, Google claims that banning the practice of competitor keyword bidding hands brand owners an unfair monopoly. Shoppers routinely search specific brand names to identify and assess alternative products, making keyword bidding an essential tool for consumer choice. This frames their legal challenge as defending a competitive digital marketplace, overprotecting their profit margins. The original judgment criticized Google for double standards, pointing out that the company complies with stricter trademark protections in Europe while allowing broader use in India. This map highlights Google's counter-argument that the Delhi High Court ruling actually makes India the sole outlier, diverging sharply from established digital practices worldwide. Through this massive appeal, Google seeks to realign Indian law with the current established international norms of the global search advertising market. If the upcoming appellate hearings uphold the initial ruling, it will rewrite the economics of the online advertising market in India, threatening utility and revenue for major tech networks. While Google pushes back, prominent Indian firms like Shoddy.com and Zerodha have openly celebrated the ruling, viewing it as a legal pathway to stop competitors from free-riding on their established brand equity. The final appellate decision will test whether search engines can continue operating as neutral intermediaries, or if they will be held legally responsible as active participants in digital market competition.
Imagine you are running a race. You've put in the miles, built up the stamina, and the finish line is right in front of you. But just as you cross it, another runner bursts in from the sidelines, shoves you out of the way, and breaks the tape. That is exactly what it feels like to build a brand on the internet today. You type a specific company's name into a search engine, and the very first link you see is an ad for their biggest rival. Google's advertising infrastructure is intentionally optimized for this scenario, a multi-billion-dollar digital trend known as competitor keyword bidding. To stop rivals from poaching their customers at the final click, companies are forced to bid on their own names. They end up paying search engines massive sums of money just to defend the trademarks they already legally own. This cycle of defensive spending has become a foundational mechanic of Google's global advertising revenue. Then, in May 2026, the High Court of Delhi struck a blow to that model, declaring this exact bidding practice illegal within India. Google immediately challenged the decision, filing a massive 4,761-page appeal to block the judgment. The tech giant is fighting this because a loss in India threatens to unravel the internal economic logic of its entire ad system. This single Indian court ruling represents a literal wrench in the gears of the worldwide digital advertising ecosystem. The dispute started with Hindware, a major Indian sanitaryware brand. They noticed their organic search traffic was being siphoned off. This diagram shows the mechanics of the hijack. Competitors bought the name Hindware as an invisible trigger on Google Ads. When a shopper searched for the brand, the system redirected the top slots to rival websites, artificially diverting organic traffic away from the original company. Hindware argued they were being penalized for the popularity and equity of their own brand name. The High Court agreed. They ordered Google to pay roughly $31,600 in damages and issued a permanent ban preventing the platform from using Hindware as an ad trigger. Crucially, the judge found that Google could not claim to be a neutral intermediary. The court noted that Google's keyword planner tool actively suggests rival brand names to competitors, steering trademark terms into the auction to maximize profits. Justice Mini Pushkarna reached a blunt conclusion. Google has attempted to sell something that it simply does not own. Google's appeal rests on a technical distinction. They argue a keyword is merely an internal backend trigger, not a public-facing trademark violation. They further argue that allowing competitor bidding promotes healthy competition, giving shoppers the chance to realistically compare all their alternatives. Google warns that banning the practice gives brand owners an unfair monopoly over search results, making India a sole outlier against standard global digital practices. This creates a direct ideological clash. Google views its system as a protector of the open market, while the court views it as a system facilitating corporate theft. The judgment has already caused a ripple effect across the broader Indian business ecosystem. Prominent digital firms like the matchmaking platform Shaadi.com and the brokerage firm Zerodha have publicly celebrated the ruling. These companies see a clear, court-tested pathway to stop competitors from free riding on the brand equity they spent years building. The ruling has emboldened a wave of corporate resistance against the rules Google sets for digital advertising. If the appeal fails, advertisers will lose their most effective tool for intercepting high-intent customers right at the point of search. Marketing departments would be forced to shift their budgets away from competitor keyword bidding entirely. This chart projects a potential reallocation. Capital currently tied up in bidding wars would likely begin refilling budgets for organic SEO and traditional brand building. If this Indian precedent survives the appeal, it provides a legal mechanism for other nations to challenge the practice of forcing brands to pay for their own search results.